This is Mark Spitz with Spitz Legal Counsel. Today I would like to talk about choice of entity. If you're forming a company, if you're an entrepreneur and you want to start a new company, what form should that company take? Should it be a corporation or should it be a limited liability company, an LLC? Corporations have been around for a long time, hundreds of years. LLCs have been around a lot shorter time, since the 1990s. So they are a newer form of legal entity, but over that time, they have become the most popular form of entity for small companies, and the great majority of new companies that are formed are limited liability companies. However, there are some common aspects to corporations and LLCs, and there are some differences which you need to consider when you decide what type to form. So what's the most common attribute of LLCs and corporations? That is the feature of limited liability, meaning that the owners of the entity, whether it's the shareholders of a corporation or the members of an LLC, do not have personal liability for the actions of the corporation or of the LLC. So for example, if the company pollutes a river by dumping something in the river, the shareholders or members of the entity, depending on what type it is, are not personally liable, only the entity itself. So that is a feature which is common to both and has made limited liability companies very popular. There are some differences though, and let's talk about those. One area is that of management. Corporations are governed by state law, and state law requires corporations to have a director or board of directors and officers, a president, a treasurer, a secretary, vice presidents, and so on. LLCs are much more flexible. They're not required to have directors or officers. They can be managed either by the members or by managers who may or may not be members, and the management is much more flexible. And that's one of the reasons that especially small companies and entrepreneurs really like the LLC form nowadays. Another area related to that is formalities. As I mentioned, a corporation has to have a board of directors, it has to have officers, it also has to have an annual meeting of shareholders to elect directors, it has to have bylaws, it has to have resolutions and minutes and good record keeping. None of those are required for an LLC, but as the attorney for many LLCs, I always recommend it is a good idea to have good record keeping to document important decisions that the members or managers take. It's just good practice, especially if you go to get a loan or go to sell the company down the road. Now, another important area is income and taxation. An LLC is what's called a pass-through entity, so the income and expenses of the LLC pass through to the members who report that on their individual tax return on Schedule C. One of the advantageous features of the LLC is that you don't have to distribute the income and expenses on a pro rata basis. If the members agree, then the income and expenses can be distributed on some other basis. With a corporation, income has to be distributed on a pro rata basis according to shareholder percentages. You don't have to do that with an LLC, although if the members don't agree to do that, then it's also distributed pro rata. The other feature that corporations have that an LLC doesn't is a corporation has what's called double taxation. The traditional C Corp, and I will talk in a minute about an S corporation or S Corp, but the traditional C corporation is subject to what's called double taxation. The corporation itself files a tax return and pays taxes on its profits. Then when it pays a dividend on those profits to the shareholders pay tax at ordinary income rates on the dividends they receive. So there's the double taxation. If a corporation elects S corporation tax treatment with the IRS, it becomes a pass-through entity like an LLC. So income and expenses pass through to the shareholders and the corporation itself does not pay taxes. However, an S corporation has some limits on the number of shareholders fewer than 100. And the type of shareholders, they have to be individuals who are U.S. citizens or residents. They can't be a foreigner who lives, say, in France or India or someplace like that. So there are some restrictions on the S-Corp status, but S-Corps are also very popular with small companies that start out as corporations. Now, investors like corporations. So if you have a corporation or if you are forming an entity that you hope to grow and get angel or venture capital investors who are going to want equity, they prefer a corporation. They want to get shares rather than a membership interest in an LLC, oftentimes because the venture capital investors are funds or entities which cannot take the pass-through form of income. So if you are thinking you're going to scale up, you're going to get investors down the road who are going to write big checks, a corporation may make more sense. If you're not going to scale up and get outside venture capital or angel or other big investors, an LLC may be better, and you can always convert the LLC to a corporation at a later date. Now, one other thing I want to mention before I close is even though the management of an LLC is very flexible, I always recommend that an LLC have an operating agreement. And I mentioned that in another video that I've done earlier. The operating agreement sets out how the LLC is going to be managed, who has what authority, and also has very important provisions on the restriction of transfer so that members cannot freely transfer their membership interest. That protects all of the members. Corporations should have what's called a buy-sell or a shareholders agreement, and that, while it doesn't deal with management issues, also deals with restrictions on transfer, which is a way to protect the shareholders from finding out one day that one of their shareholders has sold his or her shares to somebody who the remaining shareholders don't know or don't like, don't want to deal with. So I always recommend that operating agreements for LLCs or buy-sell agreements for corporations be put in place. So if you have any other questions, please feel free to contact me, Mark Spitz at Spitz Legal Counsel. My email and my phone number will appear at the end of the video. Thanks again, and please look forward to future videos.